Good afternoon to everyone. And Madam, thank you for the introduction. You are a sight for sore eyes. So I'm going to discuss about corporate governance. And what part of corporate governance will I discuss to you? It is about data governance. How does a company manage the data assets? So, what is data governance? Data governance is the management of all data assets of the company to ensure that the data is secure, private, accurate, available, and usable. If you have a robust data governance in your company, nothing will go wrong unless you are hacked by clever hackers and you fail in your cybersecurity measures. But those kinds of events are inevitable. It will happen to you if you are really attacked. Now, part of a good data governance is the creation of a privacy management program, a good privacy management program. What is this? PMP. It is a proactive approach to privacy and data protection. It minimizes the risks of privacy breaches and maximizes the ability to address underlying problems and reduce the damage arising from said breaches. And what are we going to include in a good privacy management program? Number one, your privacy policy. What will be the policy of our board of directors in our company? Are we going to be lenient in the implementation of privacy measures in the company? Yes or no? Siyempre, yes. Of course, yes. Because if not, you will be in violation of the Data Privacy Act of 2012. And you will see my face accusing you. You are not compliant with the Data Privacy Act of 2012. Here is the show cause order signed by me. And the penalty for violation is up to 5 million pesos. Oh, we would not want that. That is profit for our company already. And surely we do not want to lose it in a poor privacy management program being implemented within the organization. Okay, so privacy policy. For example, in your privacy policy, the company must implement acceptable use policy. Each employee must sign an acceptable use policy so that they will know and be responsible for whatever they do, or if they access the infrastructure of the company. And next, we have the privacy notice. Are we going to tell our clients that the data we collect from you is going to be utilized in some other manner or being shared with other companies, just like what we do in the banking industry for data sharing agreements? We share the data that we collect. We share the financial data of our clients to boost the economy. Next, we have, for example, the CCTV notice. Are we going to let our clients know that whenever they visit this premise, they are being recorded? Yes, that is required by law. And on the more technical side, are we going to incorporate privacy by design or privacy by default in our privacy policy? What is privacy by default? Privacy by default means that whenever someone transacts with your company, that someone does not need to worry anymore that his privacy will not be protected by the company because it is automatically protected by the company. There is nothing left for him to do but to say yes to the forms that he fills out or whatever. And what is privacy by design? Privacy by design is privacy through the use of technology. Are we going to implement artificial intelligence in the implementation of our programs and systems? Are we going to use machine learning or blockchain technology, Internet of Things. Next part of a good privacy management program is, of course, you conduct a privacy impact assessment. Please do so. Please know where there are risks that is posed by your pursuit of your company purpose. And know how you are going to address those risks. And you put it in a good privacy manual. Number 3 of a good privacy management program is that you have data privacy safeguards implemented throughout the organization. And when I say safeguards, this I am referring to cybersecurity. Of course, cybersecurity, are we going to implement PETs or privacy-enhancing technologies in our system so that we protect the data that we collect? That is advisable, yes, but is it expensive? Maybe so. But the cybersecurity, please note, must always be commensurate to how big your organization is. If you could afford a good cybersecurity measure, please implement it, lest you be like a PhilHealth. What happened to PhilHealth? They were in violation of the Data Privacy Act of 2012. Why? Because they were hacked and the data of their clients were stolen. Why? Because their antivirus was expired. That is now, we now come to the 4th part of a good privacy management program, and that is to have as backup your incident management protocol. If you do not have a good cybersecurity, then surely your data might be stolen. But in that case, you must have a backup plan. And that backup plan must be written in an incident management protocol. Are we going to have a disaster recovery plan if the data is not accessible, if you are using cloud computing technologies? If you're using the cloud, are we having an issue with data governance? That's why there is a move in the Philippines for data localization. We will no longer be held hostage by those servers located abroad when we put our data on the cloud. But of course, measures can be taken to prevent that just by implementing service level agreements, a good service level agreements on data governance. I mean, on data sovereignty. So next, what are the parts of an incident management protocol? The reportorial requirements. You have 72 hours to report to the commission if you had a breach. You will ask our permission if you would not want your clients to know that their data were stolen. And we will approve it or not approve it depending on the circumstances and so forth, etc., etc. The 5th part of a privacy management program is data security audits. Conduct audits, critique your system, employ vulnerability assessment penetration testings so that you will not find fault in your cybersecurity measures. And of course, lastly, and it is very important also, that the organization conduct an organization-wide privacy training and awareness. Let us create a culture of privacy in the organization so that everyone knows how to protect their own. The company will no longer protect in behalf of our clients who are protecting you, but it is instilled in the data subject himself or herself to protect his or her privacy. And lastly, let me remind everyone, according to Justice Douglas, that the fundamental human right and at the beginning of all freedom is with the right to privacy. And that according to Justice Brandeis, the right to privacy is the most comprehensive of all rights. And that the right of privacy or to privacy is the right most valued by civilized men. With that, I thank you, and thank you for having me here. Good day to you all.
Thank you very much, Sir Aubin. Maybe we could take this time, since we have a few more minutes for this session. Will it be okay for you to entertain some questions from the audience?
500 per question.
Any brave soul who would like to raise their question, just approach the microphone on the floor. Come on, take this opportunity. It's only once in a blue moon you'll meet someone as he is. Go on, miss.
Hi, sir. Good afternoon.
Good afternoon.
Thank you so much for being here. I'm glad to have this opportunity to ask you a question. Personal data is something that is, of course, it's in a sense a property of the person.
Yes.
So we have one of the biggest issues of banks right now is the selling of accounts, meaning that the personal data of an account holder is sold for a particular sum to a person that might use it for nefarious purposes, which is actually contradictory to the innovations that we try to do with open banking. What will NPC do, considering that it is my data and I have every right to do whatever I please with my data? Would selling my data fall under any criminal action under the Data Privacy Act?
Okay. So what would the NPC do? The answer would be, you need to file a complaint with the National Privacy Commission. And when we find fault in the person subject of the complaint, then we will impose fines. And there is, I think, criminal liability of imprisonment, depending on the circumstances of the case. And in your case, if it is surely or used in a nefarious scheme, then by all means, the National Privacy Commission would impose the administrative fines under the law.
So it is an administrative fines underneath for us, for a personal.
Yes, administrative and criminal liability. When we find criminal liability, we will endorse it to the Department of Justice for criminal prosecution, so that that person who faulted you will incur the full wrath of the law.
Oh, thank you very much. That's actually very assuring to us because honestly, it's a new thing. Well, not really a new thing for banking institutions, but the idea of having NPC as a sort of implementing body to data privacy violation. I have just one more question. I hope you don't mind, sir. So right now, personal data it's a difficult thing to reconcile the bank secrecy law with the data privacy law, as well as trying to move forward with anti-fraud and illegal actions, anti-money laundering actions. So what is NPC doing at the moment in order to reconcile all these particular conflicting legal institutions? One is the protection of the secrecy of bank deposits, and the other, of course, is the sort of execution of actions that will help anti-money laundering policies.
Yes. Well, for that question, it's a little bit complicated, you see. We continuously issue circulars on that matter because I want you to understand that the Data Privacy Act of 2012 was rushed into law by our congressman in 2012. Why? Because a very big investment in the Philippines was not pushing through because these foreign investors were asking, where is the data privacy law of the Philippines? That's why we just arrived in copying the GDPR
Actually, yes.
in Europe. And the GDPR in Europe is not applicable in the scenario of the Philippines. This is a different culture. That's why Are there irreconcilable differences? Yes, there are differences, but are they irreconcilable? No. That's why we continuously write and upgrade our circulars to address your questions. The Commission is a young watchdog for privacy, and we will continue to grow. I assure you of that. And for matters that worry you with regard to the bank secrecy and anti-money laundering, we have committees already built for that, and the NPC is a member of those committee. So rest assured that we are addressing all issues that you have brought before me today.
Thank you, sir.
Thank you very much.
Much for the assurance. Have a great day. Thank you.
That is 1,000 pesos.
GCash? Do you have CIMB app?
All right, so we have one more question.
Maybe you have a question?
Definitely none. Okay, one more. Okay, go ahead, Sir JC.
Good afternoon.
Good afternoon, sir.
This is about the data sovereignty. You mentioned, about, Filipino PII should be in country.
Yes.
Yeah, and currently right now, most of the companies, are actually subscribing to the cloud, whether it's Azure or whether it's AWS. It's either in Singapore, Japan, which are the nearest, geolocation. So what would be the take of, is this going to be mitigated by a procedure for clarity that, or is it going to be a mandate coming from NPC to bring it back in the country?
Well, this move is not coming from the NPC. This is just being talked about in the Department of Information and Communications Technology. But that is just a plan. So forgive me if I have stirred it up a little bit, but don't worry. It's just a plan. Because for now, we still follow the cloud-first policy of the DICT.
All right.
The organizer informed me that we are going to have a raffle,
Oh, yes, all right.
house and lot.
Okay, you've already spilled the tea, Sir Aubin. Ladies and gentlemen, let's give a big warm of applause
Thank
to
you.
Sir Aubin.
Thank you.